So the next case we're going to do is R.A.V. versus St. Paul. Um, and in this case, the factual setup is there was a group of teenagers who were charged with violating a statute in St. Paul, Minnesota, when they burned a cross on a black family's lawn. And the law in St. Paul prohibited the display of symbols that reasonably would arouse anger, alarm, or resentment in others on the basis of race, religion, or gender. So one could see how burning a cross on a black family's lawn might run afoul of this law in the city of St. Paul. But we have to remember what the First Amendment generally protects against. So the issue in this case, before we deal with the actual opinion, is does a law which prohibits symbols engaged in a content-based regulation that is in violation of the First Amendment? Justice Scalia writes this opinion. And this is one of Justice Scalia's very good, very articulate, very, very well-reasoned opinions. He argues that the First Amendment generally prohibits the government from restricting speech and even conduct simply because others will disagree with it. That's one of the focus points of the First Amendment is the government can't squash speech because someone does not like the speech. That was largely the precedent from Cohen v. California. And so this regulation exists as what would be a content-based restriction. Applying these principles, even narrowly construed to the ordinance in question, the ordinance is very clearly unconstitutional. And he says that because only race, religion, and gender are included, it includes a lot of other areas, such as political affiliation, union membership, homosexuality. And therefore, since it targets a very specific types of speech, it's a content-based restriction by definition. It's focusing on content. And so he weighs in that the First Amendment does not prohibit St. Paul to impose prohibitions on those speakers who express views on disfavored subjects. He goes on to say, let there be no mistake about the court's belief that burning a cross on someone's lawn is reprehensible. But St. Paul has sufficient means at its disposal to present such behavior without adding the First Amendment to the fire. Basically, his argument is there exists a law. There exists a few laws that can get directly arson, vandalism, any number of laws that would be able to get at this behavior, target this behavior, and prosecute these individuals. And you shouldn't have to go to targeting the content of an individual's speech in order to get at a behavior such as the one that was in question in this case. Justice White, Blackmun, O'Connor, and Stevens concur in the judgment. So they agree in the outcome of the case. They would have, however, argued that the statute is overbroad, which means it covers far too many things. Because in their viewpoint, it criminalizes both protected and unprotected conduct. And so while they agree with the outcome of the case, they argue that the statute in question is invalid, not because it's a content-based restriction, but because it's overbroad in that it criminalizes activities which one would consider to be protected speech and others which would consider to be unprotected conduct. And so the conclusion of this case is that ultimately these hate crime laws that target speech and not behavior, and that's very different. Remember that separation that we talked about earlier on. There's a very different way to approach restrictions that restrict speech versus conduct. Conduct doesn't rise to the same level of protection as speech, but speech rises to a huge protection. And so their argument is that there's unprotected conduct of which burning a cross on someone's lawn is conduct, whereas burning a cross in the middle of a forest at a rally is speech. They're different actions, and one should be protected and the other shouldn't be. But despite how the majority lines up, it's a unanimous opinion stating that the law in question, the St. Paul Ordinance, is unconstitutional.